Okay, well, let's kick off. Thank you, everyone, for jumping on to our monthly webinar. I am Alex, the co-founder of Sprintlaw, and we also have Jackson here, who is a special guest. He's a trademark examiner from IP Australia, and we'll be covering today a topic that we get a lot of questions about from our clients, which is intellectual property. And the title of this presentation is IP Made Simple: How to Protect Your Small Business. Just to give a quick intro to Jackson, and he'll talk a little bit more about IP Australia in a moment, but Jackson is a trademark examiner at IP Australia. For those that don't know, IP Australia is a government agency that handles IP law in Australia. Jackson is the person that reviews a lot of the trademark applications that get submitted, including those that you may have submitted or may submit in future. So he knows this stuff really well, and he also received a Directors General Award in 2023 for his contributions to the Trademark Checker tool, which is a really awesome tool that I think we're going to get a demo of later to make it easy for businesses to check trademarks and availability and so on. Just a quick introduction to Sprintlaw before we get into the content for today. We are our online law firm for small businesses and startups. We, unlike traditional law firms, don't charge by the hour. We do everything on a fixed fee basis. We cover all the different areas of law that your business might need help with, from setting up companies, terms and conditions, contract drafting, employment law, all the way through to IP, which we're talking about today. We have an optional membership, but the majority of our small business clients sign up to it, and it gives you access to a legal helpline where you can chat to our lawyers anytime, discounts on our services, and a bunch of other tools like e-signatures and so on. We've actually just launched a new platform last week. So for those interested, you can hop onto our website and actually create a free account. It's a bit hard to find because we haven't fully launched it on the website yet, but if you scroll to the bottom, there's a button that links you to set up the free account, and it's got a ton of awesome features to check your legal health and so on. We're a team of a bit over 50, have a bit over 6,000 small business clients, operate in Australia, the UK, and New Zealand, and have won tons of industry awards. So if you're not already a client and you need legal help, do feel free to reach out, and we offer, and I'll have a link to this again in the chat and at the end, free initial consults for anyone that has IP questions at the end of this prezzo. And Jackson, maybe you just want to give a quick intro to IP Australia.
All right. Hey, everyone. I'm Jackson. As Alex said, I'm a trademark examiner. I'm not a professional public speaker, so please forgive any fumbles. So IP Australia are the Australian government agency that administers intellectual property rights and legislations relating to patents, trademarks, design rights, and plant breeders' rights. So we contribute to the innovation system more broadly by using our skills and experience to advertise government and Australian businesses to make the most of their IP. So part of our role as an agency is to increase awareness and engagement with the IP system for Australian businesses. So thanks to you, Alex, and the team at Sprintlaw for having us here today.
Fantastic. So here's what we're going to cover today. We're going to go through, first of all, what is intellectual property and what are the different types of intellectual property, and how can you protect your business's brand and ideas. We're then going to do a deep dive into trademark, and Jackson's going to explain what trademarks are, how the process works, and what happens if someone's using a trademark. We'll then touch on copyright, another important aspect of intellectual property, and confidential information as well. To the extent that you have questions, we're going to mostly save them for the end, just so we can make sure we get through the content. But if you want to drop them as they come to your mind as we're going through the slides, do feel free, and we'll see if we can answer some of them along the way as well. But yeah, we'll set aside a little time from end to kind of make sure that we cover off what everyone's asking. So, what is intellectual property and what are the different types of intellectual property? Well, intellectual property refers to the intangible creations that individuals or organizations may make, and they're kind of assets that you want to make sure that are protected and owned. In the context of businesses, there's many different types of intellectual property, but we have the main types on this slide. We have trademarks. So trademarks are sort of registrations that you can make to protect your name, a product name, a logo, a combination of the two. There's a few different categories, colors and things, and they give you the exclusive right to use those things in a particular industry, in a particular country. So very important for businesses who are investing in their brands to make sure that they have the right exclusive right to use those brands, that they're not potentially infringing someone else's brand. Really, it's and why we're spending so much today focusing on it is kind of a must do for pretty much any small business that's out there promoting their brand. So that's the trademark. It's about the brand and the name and the logo and so on. Copyright refers to original ideas recorded in material form, and it's more about those kind of creations that you make that are of written word or multimedia or music. These kinds of things, the moment they're created, they're owned by the creator. And of course, if you're operating in a business, if you've got original works that you want to make sure can't be used by employees or contractors that create them, you want to make sure you're protecting those things. So copyright is intended to protect authors of works, and in a business context, you may want to make sure you've got rights over those authored works that are important to your business. Confidential information, the name kind of describes what it is. It's information that you may want to keep confidential. In a business context, it's not arguably a form of property, and in fact, in a legal sense, many lawyers would argue it really isn't intellectual property. But we included it in this presentation because it's part of the same suite of protections of intangible things that your business might want to think about. So to the extent that there's confidential strategic information, confidential information about your business, your financials, your numbers, those sorts of things, or strategies that you may have, these things may be confidential, and there's various legal ways to protect them. There's two other common categories. We're not going to spend much time on them today in the interest of time. These are also administered by IP Australia. So we've got designs and patents. Designs protect sort of product designs and furniture and these sorts of things. If you've come up with an innovative product design or original product design, you may be able to get a registration for that and protect that. And patents are for inventions. Pretty high threshold of originality required for something to be classified as an invention for the purpose of a patent, but these are pharmaceutical products or robotic inventions, and these sorts of things can also be protected, again, through a registration that gives you exclusive rights to that invention. So I think we'll have some links on the final slide for those interested in those two areas, but for today, we're just focusing on these kind of first three areas. So Jackson, I might let you kick off and talk a bit about the trademarks.
Yeah, for sure. So what is a trademark? So it's often called a brand. A trademark is your identity and is used by customers to differentiate your products or services from those of your competitors. So it's not just a brand name or a logo. It may be your corporate logo, a little jingle you use in an advertisement, your business name printed on the side of your truck, or signage or packaging. So they can be a valuable asset for your business and can be in the form of a letter, a number, a word, a phrase, a color, a sound, a smell. A shape logo, a picture movement, or just an aspect of packaging, or a combination of any of the above. So a registered trademark provides you with exclusive rights to use, license, and sell the mark. So you can apply for your trademark directly with us at IP Australia by using our pre-application service, TM Head Start, or just our standard application through the IP Australia website. Or if you really want, you can work with an attorney. So the initial protection lasts for 10 years, but if renewed, protection will last indefinitely. Your trademark can be a valuable marketing tool because the value of your trademark increases with the success of your business. On the side here, we have 3 examples of registered trademarks. So we've got the Arnott's Biscuits, which is an example of how a word can be used as a trademark. We've got the Cadbury's packaging there, which is an example of how a color can be used as a mark. And then we've got Tea, which is an example of a composite trademark, which is words and then a distinct image logo. Next slide, please. Thank you. So there are a few types of examples of different trademarks. So here we've got a letter, which is the Cadbury C. We've got a number, which is 5 gum. Word, Nike. We've got a phrase, just do it, which is also Nike. We've got color, sound, smells, a shape. We've got a logo, so we've got the Tasmanian government there. We've got a picture, cute little dog. A movement. Unfortunately, I think we all know what that movement there is. And we've got aspect of packaging as well, which is the Kinder egg, I believe. So to secure trademark registration, you need to apply and meet the legal requirements. The requirements for a trademark registration are quite specific and are different to a business, company, or domain name registrations. So even if you are able to register those things, it doesn't necessarily mean that your trademark can be registered. Throughout the presentation, I'll step through a couple of the legal requirements just to give you an idea of what to expect. So registering a business company or domain name doesn't give you any exclusive rights to use your brand. Only a trademark can do this. So when you're setting up your business, you may be registering, as I said before, a company name, a business name, or getting your domain name for your business website. At this point, you should also be trying to register your trademark, as none of these other registrations will enable you to legally enforce your brand logo or your business name. So on the screen, you'll notice we're using Nestle as an example. You can see they have a different company name, a business name, and a traditional domain name, and then a selection of registered trademarks for different brands and their products. So we've got a handy little table here from Business Queensland, which helps outline the differences between a business name and a registered trademark. Registering a business name does not provide exclusive ownership of your business name. You can use a business name to identify your business, and it's a legal requirement. However, it doesn't prevent other people from being able to register and use a similar or same trade name. So as I mentioned on the previous slides, to gain exclusivity over a particular business name, you'll need to register a trademark with us at IP Australia. Next slide, please. So a couple of commercial risks. While a trademark may not be required for all businesses, if your branding is an important part of your business, you should know about the potential risk you'd be taking if you choose not to register your trademark. So we did a survey of 91 small Australian businesses and found that 48% had to rebrand as they were unable to secure a trademark. The data from the US shows that rebranding costs for small businesses cost around $130,000 to $240,000. And a survey of global brands showed that 3 out of 4 of the trademark infringements led to litigation, and the Australian legal fees involving litigation can be north of $100,000. There are also significant opportunity costs, as our own study indicates that businesses who have registered their trademarks are 13% more likely to achieve higher turnover growth compared to those without. So a trademark secures the value of your brand, and without one, it can often limit your ability to expand your investment. So we'll just go over a couple of the main things you need to know about your trademark. So goods and services. When you're applying for a trademark, you need to nominate what goods and services you'd like protection for. So there's a list of about 70,000 goods and services you can choose from. So people are often overwhelmed and struggle with deciding on what to choose. So basically, you'll want to select the things that you're offering to the market in connection with the trademark you've chosen. So most likely people are paying you for something. So you just have to try and think about what it is they're paying you for. Are you producing a tangible item that they can pick and take away? Or are you providing your expertise in a service-based offering? What's your area of trade? What industry you're operating in? Asking yourself these kind of questions can help narrow down on which goods and services you might like to select. When you're using our selection tool, you can try different keywords that may represent your goods and services to understand what might be out there. For example, if you're operating in the software space, you might want to try words like software, app, developer, computer, platform. All these will come up with different results that you can look through. So when you're selecting your goods and services, you'll need to select the goods and services that you're currently offering or that you may be planning on offering in the future. You have to use your trademark in relation to the goods and services you've selected to guarantee that it remains protected. The list of goods and services is broken down in 45 classes or categories. This is an international system to help search and apply for trademarks. The cost of the application is based on how many different classes your goods and services fall into. So you can have about 100 different items in one class and the cost won't change. However, if you've got a couple of items in a bunch of different classes, the price will go up. This is unavoidable sometimes depending on your industry. So when you're choosing your trademark, it needs to be different to other trademarks that already exist on the Australian Trademark Register and that are providing same or similar goods and services. So if you're selling goods or services similar to someone else, it's best to have something totally different and unique. So as we can see on the left there, we've got the Snickers, Cadbury, and Dara Lee, all selling chocolate. However, because their names are super different, there's not going to be an issue there. But as you can see on the right, you can sometimes use the same word as another company as long as you're providing different goods and services. Customers won't be confused as to whether or not you're the same company or not. So a registered trademark only protects the goods and services that an owner has chosen. So this is how different companies can have the same name in different things. So the example here we have is Antler. So one's offering a venture capital firm services, and then another's offering luggage and safety helmets. So generally speaking, someone who's offering venture capital firm services, they're not going to be trying to sell your luggage, and same with safety helmets. So this is the reason why these trademarks can coexist. So the next legal requirement concerns the fact that your trademark has to be able to show your chosen goods and services are coming from your business. So it can't really be a plain word or basic images that everyone in your industry should be able to use. So we'll use the word apple as an example here. So people have a genuine need to use the word apple to describe the fruit. So you couldn't trademark the word apple if that's what you're selling. However, when it's used on computer-based goods and services, it's completely different. It's not a term that others would need to use in relation to computers. So for that reason, Apple were able to successfully register the word Apple as a trademark. So you're probably wondering, when's the best time to apply for a trademark? So there's not really a one-size-fits-all answer here, but generally speaking, the sooner the better. As soon as you have your name locked in, applying for a registration of your trademark is a small investment and peace of mind. It means that you can be more confident spending money on advertising, packaging, and other branded products, knowing that you're on track to have your rights secured. As you become more successful, it's more likely that people will try to copy you to create similar success for themselves. Having that registration in your hand makes it easier to stop others from using your trademark without your permission. That being said, though, there's definitely a lot of things that you need to do and learn when you're setting up your business. So getting a trademark might not be at the top of your priority list. You might prefer to try and take the idea out into the marketplace and test to see how the name performs before investing money into the trademark. However, the risk here is that a copycat might get in first and you'd have to spend your time and money chasing after them. So I guess there's pros and cons on both sides. But no matter when you decide to apply, it's a good idea to check your name as soon as you have some ideas in mind, just to make sure that you're not infringing on someone else's trademark. So, I mean, a general Google search is great, will give you a good idea, but you can also access the Australian Trademark Register and just go through that just to see what's out there. So here's just a basic timeline for a Head Start process. So a Head Start is a pre-application that has a faster turnover rate to a standard trademark application and offers a bit more flexibility. So starting on the left there, so you'd submit your Head Start, and then roughly 5 to 7 days later, you'll receive the Head Start report. So from here, you receive two types of reports. Either you get a clear report, meaning that there were no issues found with your trademark, and you can move on to the next step. The other report would be an adverse report, meaning that there were issues found. So because this is a Head Start, if there are issues found, you do have the option to amend your trademark to try and overcome these issues. So that's one option you can do. The other options are you can either just let the trademark lapse, meaning that you don't want to take it any further, or you can still move on to the next phase with these issues in mind. But once it's transferred over to a standard application, that will give you 15 months to try and overcome those issues. However, you're a bit more limited in what you can do in terms of overcoming those issues. So moving forward, we're just going to focus on if you were to receive a clear report. So once you receive that clear report, oh, sorry, Alex, go back. Yeah, thank you. Once you receive that, you get your formal application in. That would take about a month, and then you receive an early registration notification. From this point on, you've got a 4-month waiting period, and this is just for international registrations. So this is a bit complicated, but it's not really anything that you need to worry about. It's just generally Australia and other companies have a 6-month policy if they're trying to register a trademark in another country. So that's what that 4 months is there for, just in case someone does try to register their trademark, which is similar to yours from overseas. However, this rarely happens, so it's nothing you need to really worry about. And then you've also got the opposition period, which then lasts for 2 months. And again, this is just in case anybody else has an issue with your trademark getting registered. This is when they can challenge that. However, again, this rarely ever happens. I think in 2021, it was less than 5% of this happening. So, yeah. So before you apply for your trademark, it's important to review whether it has already been held by another business. So I'm going to just run you through one of Australia's IP Australia's free tools, which is the TM Checker. So it makes it easier for you to check for similar trademarks that are already registered in just a couple of minutes. The tool also provides a lot of useful information and guidance through its help section to assist small businesses who want to better understand the trademark system and the application process. So I'll just quickly run you through a quick example now of the Head Start process. So I'll just quickly share my screen. All right. Can everyone see that?
Yep, that's coming through.
Beautiful. So got the TM Checker here. We'll just click start. So this will just run you through a couple of things which I've already explained, but I'll quickly just run you through them again. So we've got being too similar, meaning if you already know that there's a trademark that's operating in a similar space to you, try not to name try not to copy what it is. So Cadbury is an example there. Being too literal, good green apples, as we spoke about earlier. If you're selling apples, you probably won't want a trademark that's explaining exactly what it is that you're selling, which are good green apples. Geographical locations. So if you're selling apples in Victoria, you probably want to avoid using the word Victoria, as it just indicates geographical location. Images of your product. For example, we got lamingtons here. So if you're selling lamingtons, you can't just have a basic depiction of a lamington. That said, though, that doesn't mean that you can't have pictures of a lamington. You just have to, jazz them up a bit. For example, you could have those pictures of the lamingtons being held by a T-Rex that's wearing mini shorts, holding a surfboard. There's a free one for you on the house.
Love it.
And common sayings, so things like one-stop shop or best prices guaranteed. This is something that everyone's going to need to use moving forward. So try to avoid those common sayings. So we've got a disclaimer here as well. Good idea to have a quick read of that, but we won't go through that now. So moving forward, I'm going to use Sprintlaw as an example here. So this is where you would choose either a word or phrase, or if you've got a logo. So we've got the Triple J drums there, or you can just choose the words Triple J. So we'll go with just the words. Let's separate this bit. All right. Moving on. So this is where you would choose your goods and services. So this is the selection tool. So Sprintlaw, they operate in a legal space. So let's just move on and just type legal, see what comes up there. So we got here class 45 legal services. That seems to cover what we're doing. So down here, you see we've added the class. So that's the basic cost. So that's the minimum cost, $330. However, if we were to add another class, let's say Sprintlaw, everyone's loving Sprintlaw. I'm going to want to buy a hat from Sprintlaw. So let's look up some clothing. Search that. Basic clothing, that looks good. Let's click that. So you can see that now that we've added a separate class, it's added a cost to the price. However, if we wanted to add a couple of other items in that same class, let's go work clothing here. Because this is already in the same class, it's not going to add anything else to the price. It just depends on how many classes you've selected. So that's all looking pretty good. I think we'll move on to the next step. So this is where the AI tool is working, and it's going to try and see if there's anything similar out there, or if there's any kind of issues. So here we've seen one warning, meaning that it's picked up something that could be a potential issue. So we can just click here. So here it's showing 20 matches that could be similar to us. So the first one here is we can see that someone's already got Sprintlaw registered. That's meaning it's going to be an issue for us. So from this point on, we can choose to either try a different trademark, see how we go, or you can, if you'd like, move forward with knowing the risks that there is a similar trademark out there. Down here, we've got a nice little video, which goes for 90 seconds, pretty much explaining everything that I've explained, except in a much smoother way, I like to think. Then if we're happy with all that, we can just apply. Just got a little run through of the timelines. Got that 7-month waiting period, which is from start to end, which I explained earlier. Got some good information there. And then we just apply. We just keep moving. And then you just have to pay for that. So I'll just quickly show you another example here. I've already done one called Pizza Shop. So I typed this one in just to show you a distinctiveness warning. So if we click on that, it's just essentially saying Pizza Shop is explaining exactly what it is that you're trading in, meaning that other traders would need to use that. So therefore, that's going to be an issue. So this relates, again, back to that Apple example. If you're selling apples, you can't really use the word Apple. Beautiful. So I'll stop sharing that. And then I think we've got one more slide to go through. So when you are registering your IP, it will be published online. So this is so that others in the marketplace can be aware of what you are protecting. So meaning that if you are successful in getting your trademark registered, it is up to you to enforce it. So sometimes this can mean litigation, which can be costly, but I just want to share 3 cheap and direct ways that you can protect your brand with a trademark that costs nothing except just your time. So the first one would be Google Ads. So if you have a competitor that's using your name in their advertising, you can submit a trademark infringement with Google. If successful, the ad can be removed and then the advertiser penalized. A competitor can still bid on your keywords, but they can't use your name in copy. So this is an essential reason for getting a trademark registration. Second one would be Australian domain name removal. So if you find another provider using your exact trademark in their URL or domain name, you can seek to have them removed by the AU domain registration through their appeals process. The third one would be customs border. So you can submit a formal notice to the border force if someone else is infringing on your trademark and bringing in goods into the country for commercial purposes. So there are a lot of handy tips and more information on monitoring and enforcing your IP on the IP Australia website, and just the link that's provided there on the screen. So that's it for me. So we'll go back to you, Alex. Thanks.
Thanks so much, Jackson. And I've noticed we've got a few questions that have come through on the trademark. So just before we jump into copyright, maybe it's a good time to just answer these questions while we're on the topic. Yeah, and I guess before we do that, I just wanted to maybe make a couple of additional comments. As Jackson's kind of mentioned, trademarks are a super important protection for businesses, and particularly on this slide. Also, in our experience, we've been operating for about 7 years. I would say a failure to trademark a business's brand is the number one legal issue we see small businesses face in all areas. Whether it's issues with their terms, incorrect business structures, disputes with clients. This one is the one that is the easiest to protect against and the most costly. As Jackson kind of pointed out, it takes really up to 8 months and sometimes longer to even secure a successful trademark. So there's a really strong argument for early on in your business journey, once you got a brand that you like, before you start spending money investing in promoting it, building all of your collateral, just making sure you can get the trademark and that no one else has the trademark. When we do our legal health checks, we talk a lot about this, and also shareholders agreements for founders as an important point. And now, one of the questions we had from Basima was, when you say infringing a brand, how close can another company get to the original creator company's brand? I think Jackson had a slide. This one. So the answer to that question is nuanced, basically, and it will just depend on the situation. If you're out there, and it's similar to that opening screen Jackson showed on the TM Checker tool. If you're out there promoting, Cadbury with an E, selling chocolates, very high probability that you're going to be infringing Cadbury's trademark for chocolate. But if you're running an IT company that is called Cadbury, it becomes a bit more nuanced. And you can see on the right here, we've got this example of Antler in different goods and services, but with similar trademarks. So it's difficult to give a black and white answer how close it can become. And this is what lawyers spend a lot of their time advising clients. If someone's copying someone's brand, they may want to enforce their trademark, and then we have to, as lawyers, assess whether the usage is infringing. And we consider it roughly through the lens that I kind of described. But yes, it's not black and white, but that gives you a little bit of a flavor for how you might think about infringement. So yeah, anything you want to add to that, Jackson? Or
I mean, yeah, you pretty much nailed it. It comes down to phonetically if the words are the same, and also the overall impression. For example, you could have, let's just use Snickers as an example. You could have Snickers treats versus Snickers lollies, because lollies and treats are pretty much the same thing and they're descriptive of what it is the goods are. That's still going to be an issue, as Snickers would still be seen as the main and prominent memorable element. Same with if you had Snickers spelt Snickers. If you had Snykerz, even though there's a few differences in there, it's phonetically still going to be pronounced the same and therefore given the same impression. So that's still potentially going to be an issue there. Yeah.
Gotcha. So Madeline has asked, is the IP address a type of IP? My telecommunication provider is sharing my IP address with another party. That's a question we've actually gotten quite a bit. No, they're different concepts. It's actually, I would argue, a coincidence that they're both abbreviated to IP. That's more your kind of computer's internet protocol identifier, or your internet provider's one. So yeah, if you've got an issue with your IP address being disclosed, that's more of a privacy concern and not something that I guess we're covering today, but you can reach out to your telecommunication provider if you have concerns around that. And there's some regulations around, privacy of IP addresses and so on that may or may not be relevant. Jeffrey has asked, can you use the TM symbol before it's actually trademarked? So Jackson, maybe you're a better place to answer this, but my understanding is the R symbol is regulated, but the TM symbol is unregulated, although there may still be risks with using it if under other laws. If you're representing that you have a trademark, you might not be breaching the law that requires a registration before you use the R mark, but you may be representing to the market that this is your trademark, and someone else who has a registered trademark could make a claim against you for misleading or deceptive conduct or some other kind of legal claim. So it's a little risky to use it, even though it's not as regulated as the R mark. But certainly we do see clients, once they pass particularly that initial head start process, they do start using it. Of course, we advise of some of those kind of lower order risks. But yeah, Jackson, anything you wanted to add to that, or?
No, you pretty much nailed that on the head there.
Yeah, cool. Bassam has asked, can you add goods and services to already registered trademarks? Yeah, maybe I'll defer to you on that, Jackson. I think the answer is yes, but there's a process, but yeah.
Yep. So with a standard application, you can't expand the scope of your goods and services. So you wouldn't be able to necessarily add another class. But if you had a broad claim for clothing, for example, you would be able to limit it by adding additional claims like women's clothing or hats, men's clothing, because that initial claim for clothing is so broad. So anything that is encompassed by that, you can add. However, you wouldn't then be able to add, if you've claimed clothing and nothing else, you wouldn't be able to add, legal services, because that's completely expanding the scope.
Gotcha. Could you do another? So let's say Sprintlaw decided after your demo that we wanted to get into clothing, which I'm inspired to do. We have some pretty cool merchandise. We don't have that in our Class 45 registration. Could we do another filing to add it if we wanted?
Correct.
Yeah.
If you then, once you've already had a registered trademark that doesn't include clothing, you would then have to apply for a brand new trademark, which includes clothing.
Gotcha. Makes sense. Mark's asked, if I register with IP Australia, is there a way I can achieve global protection, or is it limited to the Australian market only? So, I mean, IP Australia, as the name suggests, is the government agency for Australia. So the protection that you're getting through the process we talked about is limited to Australia and the classes in which you register. There are separate trademark bodies in separate countries. There's something called the Madrid Protocol that we often use with a lot of our clients, which and allows you to somewhat easily upgrade your Australian registration to international registrations through a kind of global registration process. It's not available in every country in the world, but there are many, many countries, the US, the UK, and others that are party to the Madrid Protocol, and it makes it a lot easier to turn it into a global trademark. And an advantage is the date of your submission, as long as you file the Madrid submission within a reasonable time, I think it's 5 months or some amount of months after the Australian application, your date of submission is considered to be the date that you filed in Australia. So a lot of our clients that want to go global from the early days of their business, we do suggest they do it. To give you a case study of Sprintlaw, we did do it from day one in the markets we wanted to go to, and we didn't actually secure our domain names in some of the markets we wanted to expand to in the US and Canada, and we've managed to, through similar processes to what Jackson mentioned earlier about lodging domain disputes when someone's infringing a mark, we managed to win back our domains because we had the foresight to have registered our trademarks early on. So even if you're not sure if you're going to go to another market, but it is really something you're thinking about, it's expense involved, but we do suggest considering doing the global registrations from early on. And yeah, Jackson, anything you want to add to that one, or?
Again, I think, yeah, you nailed that one.
Okay, we got a bunch of trademark questions flowing through, but they're good questions. So maybe we'll spend maybe 5 more minutes on this, and then we'll flick over to the copyright one. So question on distinctiveness: is there a difference between trying to trademark the word news and news.com.au? As in, does the .com.au make it a different term that is being assessed by IP Australia. Jackson, maybe you can do that one. Yeah.
Unfortunately not, because the .com.au is essentially treated as descriptive material, just meaning it's a domain name. So news versus news.com.au would still be an issue in that sense. Yeah. Only if they're claiming same or similar goods and services.
Awesome. Joel's asked a similar question. Is it easy to get global trademark when launching into other countries? Yeah, as I mentioned before, you can do that through the Madrid protocol. If you don't go through the Madrid protocol, you can always just do a domestic registration later on. And again, many of our clients do that. They do Australia first because that's all they can afford. Then they decide to expand to the UK and they do a domestic registration later. The risk, of course, and we've had this happen with some of our clients, is their trademark's perfectly fine in Australia, but there's another brand operating in the UK. And the example I gave with the same trademark, and we've had, unfortunately, more than a couple of scenarios where had they done the Madrid on day one, everything would have been fine. Because they waited some years, it became very difficult for them to secure the trademark in the other countries. So yeah, look, it's a consideration. All this stuff is about trading off the cost of acting now and the risk, but that's kind of how the process works. Renata's said, what happens if I change my logo? Do I have to register it again? I believe the answer is basically yes. If you've added like a extra full stop to a design and it's pretty much identical, the original registration, again, correct if I'm wrong, Jackson, may extend to cover a very, very tiny change. But to be safe, generally, if you're making any kind of substantive change to your logo, it's a good idea to get a separate registration for that. Yeah.
Yeah, correct. Again.
Beth said, I'm going through the process of trademarking my business name in Australia. When's a good time to trademark globally? Yeah, I think I just kind of addressed that one. Ideally, immediately, but if you can't afford it, as soon as you're thinking of expanding. Steve's asked, can you trademark a phrase or motto, not common vernacular, but something specific to an industry, say a medical clinic? Jackson, maybe you could take that one. Yeah.
Yeah, of course you can. Again, it just comes down to distinctiveness. If it's something that other traders are going to need to use, not necessarily if they're using now, but because of its ordinary meaning, they may need to use in the future. That's going to be an issue. But your trademark can be almost a paragraph long, just as long as it's not descriptive of the goods and services, and as long as no one else already got there first.
Sounds good. I noticed we got a couple of questions again on the TM versus R mark for people that may have missed it. So just to quickly cover that one more time, the registered mark, the R symbol, is only available once you have a successful trademark registration. If you try and use the R mark before then, that's a breach of the law. The TM mark is not regulated, so you can arguably use that as when your trademark's pending, or even potentially before you've registered the trademark, and it would be considered what we might call an unregistered trademark. But I mentioned earlier, there's risks of displaying that TM mark if it's not fully registered, because if you are infringing someone else's mark, you could be considered to be misleading, and there's misleading and deceptive conduct laws and other kinds of legal claims that could be made against you. But in practice, it is the case that we do see our clients, given that the waiting period can be quite long, using the TM symbol prior to the getting the rights to use that kind of registered R symbol. Matt's asked, in that Lamington example, can you clarify that you could use Lamingtons if not directly selling Lamingtons, but could be in law sector, for example? No, I don't. I think, and again, Jackson, jump in if you want to add here, but I don't think the point Jackson was making was around the different industries. It was more that if you have a picture of just a Lamington, then that's not kind of going to be distinctive enough. I know that's the right word, but to be registrable, because it's in a sense too literal. It's literally just the thing that you're selling. But if you added some alterations or something original on top of the Lamingtons, it could potentially be distinctive enough to not just be the literal Lamingtons. But if the question you're asking is, could you use literal Lamingtons if you were, let's say, a technology company or the law sector? So that's an interesting question. Potentially, I think, is the answer to that. Is that correct, Jackson? Yeah.
Yeah, correct. I mean, Lamingtons don't really have anything to do with technology, so I couldn't really see an issue there.
It's like Apple doing Apple in technology, which I think was a slide we had earlier.
Exactly.
So similar concept. So yeah. So if that was a question, Matt, then that's how we think about that. So okay. Yeah, we got a bunch more questions, but we might just jump onto the copyright stuff, and I will come back to these questions at the end. And we may go a little over 1 o'clock in answering the questions, but for those interested in hearing the answers, do feel free to stay on for a couple of minutes, and we'll do our best to cover them off. So let's just kick on to the copyright stuff. So copyright is a different form of intellectual property, and the idea of copyright is to protect creative original works expressed in material form. When we're looking at this definition, there's two things that I think should stand out to people. One is this idea of originality and creativity. So copyright applies to things that are original, so in a sense, not been done before in the way that it's being done. And this underlined sentence, expressed in material form. It's often said that copyright does not exist or subsist in ideas. If you've got a creative thought in your head and someone copies it, you can't say, oh, you infringed my copyright. That was in my head. But once it's expressed in material form, maybe you've done a drawing, maybe you've written it out in a document, maybe you have created some form of media. If that media is copied, if you can see it's been, to use a non-legal term, plagiarized in some way by somebody else, then we're looking at the material form to do a comparison, and we can say potentially that copyright's been infringed. So there's many different types of copyright. There's kind of 4 main classes that we look at, plus some other subject matter as well. So we've got artistic work, so a bunch of lists there: paintings, sculptures, graphics, cartoons. We've got literary works, novels, books, newspapers, poems, musical works, songs, melodies, dramatic works, plays, screenplays, choreography. And then other subject matter: films, video recordings, DVDs, somewhat outdated these days, the DVDs, but sound recordings, radio broadcasts, and published editions. So the look and feel of a layout of a publication. Many of these may not arise in lots of small business contexts unless you work in creative industries, but certainly computer software is one. Everyone has websites, many people have applications. That can be considered copyright as a literary work. You may have graphic designs for your marketing. You may have blog posts that you write, which could be considered a literary work as well. You may have, if you have original strategies, business strategies, arguably that's also copyright protected. If you're filming content of client case studies or anything like that, all that stuff can potentially fall under the realm of copyright. So that gives you a flavor for the type of stuff in your business you might think about as copyright. Now, unlike trademarks, which you actually have to go register with in Australia, IP Australia, and you go through the process that Jackson was running through, copyright is quite different. There's no registration system. You don't sort of formally register your copyright. Ownership arises automatically upon creation. So the second the copyright is created, the second the literary work, dramatic work, musical work is created, the author owns it. The person that made it owns it. Now, of course, if you're thinking in a business context, the people that are creating your copyright are often your employees, who are the ones making the graphic designs for your ads, or writing the blog posts, or coming up with the code for your computer software. So per this opening bullet point, what would happen by default is that those people will actually own the copyright. And as a business, you want to make sure that they don't maintain that ownership, because you might want to use the software for many purposes long after they're gone. You might want to add to it. You don't want the authors necessarily to maintain the ownership. So what typically happens in a business context is, under employment agreements or contractor agreements or other documents called IP assignment deeds, but under some legal contract, there is an agreement which says that the author will transfer the business's copyright over to the business. So most people who have been an employee before will have signed an employment contract, and if it was well drafted by the lawyers, it would have a clause in there called intellectual property, which says you, the employee, agree that any copyright that you create during the course of your employment, immediately upon creation, will be assigned and transferred in full to the employer. And so that act of having that contract, what that means is, in your business, authors will create these these pieces of copyright. They'll write the blog post, the creative content, and so on. They'll own it for, you can think of it as a split second, and then it automatically kind of gets transferred under their employment agreement to your business, and your business can get ownership of it. And this is why, lawyers talk about the importance of contracts with employees and suppliers and so on, because it's really important that you have a document signed in writing. Otherwise, if you don't, under law, the IP can sit with the author. Once you own it, you get exclusive rights, somewhat similar to the trademarks. If you have the blog post, it's assigned to your business is the only one that can reproduce it, the only one that can publish it, the only one that can communicate it to the public. If you see another business or individual copying your blog post or copying your imagery or your videos or whatever it is, that's a potential infringement claim. And the copyright protection actually lasts for a very long time, 70 years after the death of the author, or if it's anonymous, then 70 years from when it was created, which is interesting because obviously in a business context, the author may have worked in the business only for a split second, but the length of your protection is tied to how long they live. But 70 years is quite a long time, and much longer than, in fact, the trademark registration. So usually it's plenty of protection for your business to be able to use its creation. So here are the kind of common assets that we see in a copyright context: software code, graphic designs, photos and videos, business templates, internal branding strategy documents. While the trademark is going to protect your name, your logo, and potentially a phrase, all those other things in your branding strategy, your imagery style and template ways of posting things on social media and so on, if they're original, may be copyright protected rather than things that you actually register. So some questions to ask if you're thinking about, do I actually own my business's copyright? Well, look, if you haven't got an IP agreement with them, if the person hasn't signed a contract, you probably don't own it. So for those of you wondering, I've paid all this money for all this work. Is it actually mine and my business? If it was created by your employees, go double check your employment agreement and make sure that there's an IP clause in there. If you've been working with a supplier or a contractor, did you sign a contract with them? And if so, check if it says anything about IP ownership to make sure that it's yours. One issue we often see is people will engage developers or website companies who will agree to be paid for their work, but their default contracts that they make clients sign says, we, the developers, actually own everything we create for you, and we can reuse it with any other client, and we can do whatever we want with it. And if that thing they're creating for you is important to your business, you might want to ask them to change that clause because it ultimately means you don't actually own the rights to what they've created, and that can really affect your business's value, if that makes sense. Particularly for software companies where the software is everything. Every single developer, whether they're an employee or not, you just want to be 100% sure they have assigned their intellectual property. Now, if you're thinking, I didn't do that and I got to do some cleanup work, there's a document called an IP assignment deed, which, assuming the author's happy to sign it, is a simple way of assigning past copyright back to a business. And we often use these for clients that have to do some cleanup work. They've got work from a year ago, they never properly got signed. So you can use those. And we in fact, often give them as a template to our clients. We think it's always good to have an IP assignment deed, which if that document's signed, it's a 2 or 3 pager. It basically says, I, the person signing it, agree to assign everything I create to the business. And even if you don't do formal contractor agreements from time to time, if you get that at least signed, you've at least got the IP. So yeah, I won't maybe go through the last 2 bullets in the interest of time because they're a bit specific. So one other thing to check as well. So we've talked a lot about protecting your own copyright, but another thing that will come up a lot in your business is you may be using other people's copyright, and you may be doing it on purpose or not on purpose. So 2 places we see this come up is blog posts. You're writing blogs, you're taking images or stock photos or non-stock photos from the internet, or you're copying and pasting blog content for your site. That stuff may be the original work of someone else. Photos protect copyright as artistic works, literary works, of course, I mentioned earlier, and other people's blog posts. So if you've taken more than a small part, if you take a substantial part of someone else's copyright, you could be liable for infringement. So you just want to make sure that either you or your team who are preparing this content are using stuff they have the rights to use. Now, these terms people would have heard of open source or stock. They're often these website companies that basically allow you to use certain types of imagery or potentially text or video content with a full license to use it however you want. And that way you can use the imagery safely, knowing that you're not going to be infringing someone else's intellectual property. So much better idea if you're writing blog posts to use those kind of websites than just grabbing something off Google Images that might be someone else's IP. So definitely make sure you've got processes in place around creation of any content to make sure it is yours and you're not taking someone else's. And for those working in technology, oftentimes when we're putting together code these days, we'll grab codes off Stack Overflow or use libraries of other people's software code, plug it together and create our own software application. The risk with doing some of this stuff is if you don't check the terms of the license of the software that you're using, you might actually not have the right to use it. It might only allow you to use it for personal use or for a single use, or it might require you to make your entire application also available on what they call an open source basis. So again, whenever you're borrowing people's software code, just be sure to check the licenses involved and make sure that you're allowed to use it without affecting what you're trying to create. How do you actually enforce this copyright? Well, first of all, make the ownership clear. You can use that little C symbol. Unlike the R symbol, it's not as regulated. And so provided it is actually yours, you can just start using that C symbol as a demonstration of your ownership of copyright work. And then people are on notice that it's yours, and that can help deter. But if you do find someone infringing your copyright, you can send them a letter of demand requiring them to take it down. Often that works. You can request payment if you can prove it's yours. Similar to what Jackson was suggesting earlier with the Google Ads stuff on trademarks, you can report it to the platforms and say this person's posting on social media using my intellectual property, and provided you can provide good evidence, they often will take it down. So many practical steps you can take, and of course, there's the legal steps as well. If you want to escalate it to sort of sue them for infringement, you'll have different causes of action. So that's everything on copyright, and I'll just chip through the confidential information, and then we'll go back through to the Q&A, and hopefully that takes us to one or a little bit past. So confidential information, I mentioned earlier, this is not really property in the sense of, copyright is really, in legal terms, intangible property that can be owned and transferred. In the same way, a trademark is a registration that, can be transferred and sold to various between businesses and people. Confidential information is not really property in a legal sense. It's just information but confidential information can be extremely important to protecting, a business's ideas and strategies and concepts. And we talked a lot about copyright, but copyright has this artistic lens to it. And so there may be things you're thinking in your business, strategies that you have, or ideas and concepts of strategic partnerships, or different things you're thinking of doing with your business model that don't really fit the lens of trademarks or copyright, and you're thinking, well, how do I protect these things? It sounds like it doesn't quite fit in. So confidential information is a nice kind of catch-all for protecting this other important stuff for your business. And basically, as the name suggests, if there's information that's important that you want to keep a secret, you can do so. And you can do that not by registering it anywhere, but actually through simply a contract. So let's say you're meeting with a potential web developer to talk about a new app idea that you came up with, and it's not really copyright yet because it's all in your head, but you don't want everyone finding out about this. You can get that developer, before you tell them information about it, to sign an NDA, non-disclosure agreement, and you can say, look, I'm about to tell you stuff, but you promise that when I tell you this stuff, you won't use it for any other purpose other than giving me a quote or telling me about how you might be able to help. And if they sign that, they're bound by that obligation under the contract. And if they breach it, you can potentially sue them for breach of contract. Same with your employees and your contractors. Same thing. Employees might get access to sensitive information, strategies, ideas, things you're thinking of doing. In pretty much every good employment contract, there's a clause, and contract agreement, there's a clause that says confidentiality, and it says anything you learn on the job that's related to the business must be kept confidential, and you can't share it with anyone without our consent. Finally, in startups doing pitch decks, you can put a slide at the beginning saying this is all confidential, don't share it with others. And generally just being clear in your emails with headings and so on even if you don't get documents signed, actually the act of telling someone, hey, I'm about to tell you a secret, or this is confidential, and recording that in writing, it's not as good as a contract, but it's better than nothing, because claims can be made under law just for someone basically spilling the beans when they knew they shouldn't have. There's something called the tort of breach of confidence, which can be used there. So, if nothing else, if you want to protect these sensitive things, use the tools of contract, or at least providing disclaimers when you provide people information so they know it's confidential. And if you do so, you may be able to actually enforce against breach. And, you may not actually want to be in court suing people for sharing your secrets, but we do find that the act of getting someone to sign an NDA or being told something's confidential is a powerful deterrent from people actually sharing it without thinking. So yeah, that's why it's a useful tool. So that's the end of the content, but guys, we've got 11 questions that we're going to attempt to get through in the remaining few minutes. I'll leave this slide up. If anyone has questions, we've got a bunch of QR codes from IP Australia where there's a ton of helpful information. Even just using that TM checker tool, which you can find online that Jackson was demoing, I think is just a really good way to learn about trademarks. If you want to speak to a lawyer, we can obviously help guide you through a trademark registration or answer questions about IP. We've got a free consult QR code in the top right corner. So thanks, everyone. So let's dive into these final questions. Going back to trademarks, there's a couple here. Anonymous asks, what about divisional trademarks? Are they only applied for when the parent trademark is yet to be registered, not accepted? Can you please explain in what circumstances a divisional application can be applied for? Divisional trademarks. Do you know what that means, Jackson? Because I'm not actually across that concept.
Yes, divisional trademarks. They are a bit complex, and I wouldn't say I'm a master of divisionals at this point. But yeah, pretty much what you've said is if you're having issues with the parent trademark, you can try to get the divisional for the child trademark, which is essentially not all of the goods and services that were in the parent. So any potential issues with those goods and services in the parent trademark, you can then kind of get rid of them and move on to the child application in hopes of getting that registered. But there's definitely more information on the IP Australia website regarding divisionals.
Sounds good. So yeah, feel free to check that out. And if you want to contact one of our IP lawyers for some questions about that, you're very welcome to do so. Maria's asked, software as a service trademark can include several activities like information provision, consultancy, financial services. What do we have to trademark, or is SaaS enough? I think for the scope of setting the description for your trademark and what's included, it is a bit of a decision from your business, but you got to make sure that you're actually undertaking the activities that you're trademarking, or I think it can open up your trademark to be challenged. In one sense, as a business, you might want to make the description as broad as possible to say all the possible things you might do. But if Sprintlaw, for example, had said that we do clothing and we never actually did clothing, there can be an issue kind of maintaining that mark, or it could potentially be challenged. That's one way to think about it. You can be broad, you can be specific, and it just kind of depends on the advantage of broad is it's a broader protection, but you also have to make sure you're doing the stuff there. Is that a fair summary, Jackson? Anything you wanted to add, or?
Yeah, no, that's pretty much it.
Yeah, cool. If you're restricted by budget, is it better to register a name, a logo, or tagline? Difficult to answer that in general terms because it kind of depends on what your business is called and what your logo looks like and what your tagline is. Some businesses have too generic a name to actually get a trademark, but they might be able to get it for their logo because the logo is original. But in general terms, my view, and again, this is just my view, would be that if you can get a name mark, it can be better because it will provide a broader protection of different uses of that. I mean, it's more of it's actually not called a name trademark, it's called a word trademark, but it will provide any use of that word by other people, even if it's embedded in their logo, versus a logo mark will be restricted more to the actual design that you show. But yeah, would you agree with that, Jackson? Or
yeah, no, I agree with that. Composite marks where it's got the logo and the words. Again, I can't give legal advice. However, that's generally the best way to go if you are limited, if you do have a limited budget, as it will give you protection for the words and the logo, so preventing other people from just trying to register the word on its own or the logo on its own. You'll act as a barrier for them.
Yep, sounds good. Ben's asked, in the context of global expansion, can you do the Madrid instead of Australia? Can the Madrid be completed instead of the Australian, as Australia is a member of it? I'm actually not sure if you can just do the whole thing through Madrid, but definitely in our experience, it's most common to do the Australian first, find out if you're actually even going to get through in Australia, and get a sense of whether the mark is going to be accepted, and then commence the Madrid process. I mean, if you wait 7.5 months, I think you lose some of the benefits of Madrid. But oftentimes, we'll have clients start the Head Start process, get past the initial examination, and say, okay, I'm pretty confident of my trademark, and then they'll start the Madrid process. So that's definitely the normal process. I'm not sure whether I don't know if you know, Jackson, whether you could, it's more of a Madrid question, but could do the whole thing through Madrid without going through IP Australia.
Yeah, off the top of my head, I'm not sure if you can just go through Madrid, but there's definitely pros in getting it done in Australia first, especially priority date. Yeah,
for sure. So yeah, that's the most common practice on that one, Ben, at least in Sprintlaw's experience. So follow-up question on this. I noticed that there's a successful trademark application for news.com.au here. How does that get approved, given there are many companies that published news and they'd need to use that word, and they all would be in the media industry? We probably have to, I don't know if you can make any comments on that, Jackson, without looking into detail. Probably have to look at the mark. It may be that the mark is quite limited in terms of the class and the description, and it may be that they had to put the .com.au there, and maybe it's a logo mark. I'm not actually sure. But yeah, there's several reasons why that might have gone through. Yeah.
Yeah, and I mean, they could have initially ran into some issues, but there are ways to overcome certain grounds for rejections. If they've been operating since, the 60s, they would have enough use to show that they are able to act as a badge of origin and not just a descriptive term. So yeah, it's very difficult to say without having all the information in front of you, but there are multiple ways that people can overcome these sorts of rejections, grounds for rejections.
Awesome. We're a bit past 1. I'm happy to keep going through the Q&A. Do you have time, Jackson, to keep going, or do you need to hop off? Or yeah, okay. Let's see what we can get through, because these are fun questions. Someone's asked, once I get a trademark registered, how long does it last? Do I need to pay any renewal fees? Probably know that better than I, Jackson. Yeah.
Yeah, so the initial registration lasts for 10 years, and then you pay for renewal, which will give you another 10 years.
Sounds good. Someone's asked, what happens to if two separate people create a piece of work, like software that's identical or very similar, do they both have copyright over it? It's a great question. If they both independently come up with the same lines of software code arranged in the same way, which is pretty unlikely but possible, there's 2 comments that could be made. One, you might argue it's not original enough for either of them to have copyright, given that they both came up with it separately. Or the second is, you might argue that they both have copyright protection. One of the key criteria for demonstrating infringement of someone's copyright is they have to have kind of been aware of the other person's copyright and derived their creation from it. So there has to be this kind of aspect of copying. So it can be a complex question, the one that you've asked. If you're asking, what if 2 people come up with the same like website or look and feel? In the context of copyright, we often look a lot more at the software code than the look and feel of a website. But again, you can have a graphic design infringement if 2 websites look identical, but if the structure is kind of common, then there may not be original enough for either of them to have copyright in the first place. But yeah, it can be a complex question, but those are some of the answers. Either neither of them have it or both of them have it, or one's infringing the other if you can show some kind of derivation. We got a question. As an Indigenous business owner, can I protect my business name that incorporates cultural knowledge through a trademark? That's a good question, which I certainly don't have the answer to. I note that on screen we have a link to Indigenous knowledge and IP short videos, which I think will hopefully provide an answer to that question. And I don't know if do you know anything about that, Jackson? Or
yeah, we've got a specialized team, the IK knowledge team, that are really good with that kind of stuff. Yeah, I don't have too much information about that, unfortunately.
Awesome. So maybe just check out that link to IP Australia's website in the bottom right corner of the screen, and you can always reach out to the team if you've got some further questions through the IP Australia website, or if you want legal advice as well. Our team, I'm sure, could research and provide some advice on that. Who owns a design or logo created using AI? A short question, but one that is filled with legal complexity. The jury's a little out on how ownership, copyright ownership of AI created works in practice. The terms and conditions vary depending on like which tool you use. Like I think ChatGPT has changed their terms a few times, but at least at one point they allowed the users to have ownership over work created with the AI. But the question, of course, becomes what was the AI trained on, and did the AI have permission to actually be granting the ownership? And there's been some lawsuits currently running in the US where people that have come up with graphic design styles, or I think New York Times is running a lawsuit as well, saying, well, you guys are letting people create stuff and saying that they own it through your tools, but you're basing it off our IP. And because copyright is property, not just a contract thing, just because ChatGPT said that you can use it, you could still be potentially liable to the original creator of the work, depending on where the law goes. So the answer is very unclear right now. There are risks, of course, to using those AI logo tools. You might want to do at least a Google image search, similarity search, to see if it's copied from something before you start using it. And I think the law, I mean, there's a lot of talk around regulations with IP and AI. So we'll probably get a clearer answer on that in a year's time when a lot of the regulations have come through. But if you've got a specific question, definitely reach out to our team. Just a few more questions. It looks like copyright lifespan. If the employee's business has been operating for hundreds of years and has not ceased, would that mean the copyright would stay with the business for more than the lifespan? That's a very theoretical question, but I think the answer to it is, no, that the copyright will end 70 years after the date of the death of the author, or if it's an anonymous author, after 70 years. So if, Woolworths had some IP, a copyright that was created in 1900, or the person that created it died in 1900. It's well past 70 years from the date that they died. That would be kind of free use for anyone theoretically. But in practice, the copyright is often refreshed and added to all the time. So there'd be rare examples of, I think, what you're talking about. But you do hear now like record labels losing the rights to songs written a very long time ago. So it can happen. 5 more. We got one from Anna. Re-NDAs, are they quite weak in reality? Look, I wouldn't say they're weak, but it is true to say that NDAs, particularly in a small business context, are not enforced that much. We don't have our clients suing other people for breach of NDA. And one of the reasons is because it's difficult to prove that someone's shared the secret. You actually have to get evidence that they shared it. And then, of course, you've got to go through the headache of suing them, which may not be worth it. So there's a couple of hurdles to enforcing the NDA. I still think that they're a really great tool because they have a deterrence effect. And it's more of a psychology than legal point, but certainly we see in practice that when we make people sign these documents, these formal legal documents, whether it's in an investment context or otherwise, people definitely think twice about sharing it. It's not going to potentially prevent it. You may not end up in court, but if you think of it more as a deterrent tool, knowing the threat of being sued is often more powerful than actually being sued in practice. Andrew said, how long can someone be bound for under an NDA? Theoretically, forever. In practice, there's usually an exception for public knowledge. So once it becomes a matter of public knowledge, which is always subjective, then you can start talking about it. But theoretically, you could have a very tight NDA that binds you forever because it's just a contract. And I guess the exception is like courts can, in some circumstances, order people to breach NDAs for some legal purpose. So they're not completely free from risk. It used to be that you could have a 1-page NDA. Using the IP NDA generator present document 7 pages long. Is it really necessary to have all the detail, or is 1 page still okay? Chris, if you jump onto the Sprintlaw platform, we've got an NDA. I believe we have an NDA that you can build yourself. Even as a free user, I think you get 1 free doc, so you could jump on that way. Or if you're an existing member, just log in and you can make it. But it's 2 pages, I think. So yes, look, there's advantages to 7-page NDAs for giant companies, but my view, it's still very possible to have maybe not 1, but a 2-pager that you can use regularly. And I agree, it can be good to have a more condensed document for practical purposes. Can you use the work of another company if you fully attribute it to them? It's not like academic works copyright. Just because you cited them may not be enough. There's certain exceptions where people in the public can reference news stories and things like that. And in practice, if you provide a blog with a backlink to someone else's post, and don't reproduce much of it, people aren't going to get start suing you for copyright infringement. But technically, if you're going to reproduce anyone else's work, attributing it without prior permission is not enough. You actually need their permission. So yes. Now, really, just to clarify that point, I'm not saying that every time you provide a hyperlink in your blog and a one sentence of this person said this in a small quote, that's necessarily copyright infringement. Oftentimes, your a small use is not enough to infringe copyright, and the attribution can help. So you don't have to get permission from every source in a blog post. But if you're copying a big portion or something original that they've created, you're going to want to get permission, and it's certainly the case for pictures and so on. How does copyright work in trademark applications? I mean, they're different concepts, copyright and trademark, as we kind of went through. Arguably, if you've got a logo that's been created by a graphic designer and it's original, there's copyright in that logo, which is separate from the trademark process, which is going to look more at, are you ticking the box for trademark registration, and is it similar to anything else on the register, and so on, and do you pass the law? So if you've got for example, this S shape in the Sprintlaw logo, we've registered that as a trademark, but we also got a contract from the graphic designer that made it to assign the copyright in that little S shape to us. So just because we got a trademark for it, it might have been open for the graphic designer to say, well, I don't care about your trademark. I still own the copyright in this original design. And they could potentially make a legal claim against us for that. So sometimes you're going to want to secure both. But they are different concepts, and one is about protecting the exclusive right to use the kind of thing that you're registering. Any other comments on that, Jackson? Or
no, again, you nailed that one.
Sounds good. I'll just do some quick ones and then end on the longer one, and then I think we should wrap up after these 3 questions because we've gone quite a bit over. Thomas has asked, where can I find the IP assignment agreement template on the Sprintlaw website? I'm not sure that we have a free template of that, but if you inquire with our team, we can draft one up for your business and provide some info on that. So yeah, just submit an inquiry form and we'll get back to you. Winnie the Pooh is now free to use, but not now those new Winnie the Pooh images have their own copyright. Is that right? I'm not super across. I saw some headlines about that, the dates of creation of Winnie the Pooh, but that sounds like it's possible that the original Winnie the Pooh, maybe stories. I'm not sure if the name Winnie the Pooh is trademarked or not, but the stories themselves might not be protected by copyright anymore because it's been more than 70 years after the death of the author. But yes, as you say, if there's new Winnie the Pooh designs that have been created recently, well, those things are original works created, a week ago or 2 weeks ago. So the copyright would commence from that kind of date. And then final question, if you want to protect and transfer company IP, including trademark, to another entity, e.g. to a parent, how is this done? Can they be transferred? Does the change in ABN need to be updated in IP Australia? Is it better to initially register IP such as trademark and parent company and operating companies? It's a fairly long question, and probably you might want to get some specific advice on your situation on that one. But to address kind of what you're talking about, like which entity should own the IP, if you've got a dual company or multi-company structure, it's very common for the trademark to be owned by the parent company. Certainly for Sprintlaw, we have Sprintlaw Australia, Sprintlaw UK, and we have Sprintlaw Group. And all of our core IP is held in Sprintlaw Group. It provides an extra layer of protection of our brand. If someone in the UK decides to sue us, which touch wood hasn't happened and hopefully never will, but if they do, we don't want our brand to be at risk, even if it all goes kind of belly up. So you can think of a holding company, or some people have an IP company, as almost like a safety deposit box for your business assets, and it can be a good idea to put the trademark registrations there. Of course, if your other entities are now using it, you need to have intercompany agreements, really because, for example, Sprintlaw UK is out there using the Sprintlaw logo in the UK, so it has a license from the Sprintlaw holding company in order to do so. So that's kind of how it often works in practice, but whether that makes sense for your specific case just depends on how you've structured everything. So yeah, definitely feel free to reach out. Awesome. Lots of great questions today, and thanks everyone for sticking around and listening to it. Any follow-up questions, of course, feel free to check out IP Australia's resources here, or book a call with our team, and we'll do another one of these next month, I think, on another legal topic. But love any feedback anyone has. As always, it really helps us make these things better. Thanks so much, and we'll see you later.